justice. Even if you are collecting, uh, recording बहुत late कर रहे हैं my dear. भूल गए आदित्य? Huh? So like under the under the code of civil procedure, the the no sooner the issues are framed under order 14, then the list of witnesses are under order 16, then evidence in chief begins under order 18 rule 4, order 18 rule 4, read with section 137 of the evidence act. Then the evidence, the examination chief can be recorded by the learned judges or by the commissioners. Lower court may city civil, small causes court, civil judge, junior division. All these evidence are recorded by the court itself. You can file the examination chief in the court itself. Even the cross examination, the judges are recording as per the High Court manual. But whereas in High Court, the evidence is normally recorded by the commissioners. The High Court judges are too busy with the important matters. Supreme Court ke andar bhi also there is a provision for recording evidence when a suit is filed under Article 131 in the original jurisdiction. Please note that here. You may not say that the High Court or a Supreme Court also record evidence. Yes, Supreme Court and High Court are courts of record. The Supreme Court and High Court have original jurisdiction also along with the appellate jurisdiction. Normally, essentially, all the trial courts are courts of original jurisdiction, like the civil court, city civil court, small causes court, civil judge, junior division, municipal court. They are all courts of original jurisdiction, and some of them also exercise the appellate court and divisional court together. In the city of Bombay, in the court of small causes court and cooperative court, they both have appellate court powers. They are also the courts of original jurisdiction, isn't it? The city civil court in the original jurisdiction, it doesn't have appellate powers. The first appeal goes to High Court under section 96, and interlocutory appeals go under section 104. So recording of the evidence is done in the CrPC more or less in the same pattern as the CrPC, subject to some modification. The rules with regard to recording evidence in CPC are more exhaustive. Like the provision with regard to filing of list of witnesses under order 16 are not the provisions of the CrPC, but the magistrate passes an order under 135 that you are hereby called upon. But as regard the admissibility of document denial, it contained both in CPC and CrPC. In CrPC, I pointed to you section 294, the admission and denials are there, taken care of. Admission denial. And in the CPC, order 12 rule 2 ke andar admission denial takes place, isn't it? We read it out here last time. I won't be reading it here. Then affidavits are tendered in the CPC compulsorily under order 18 rule 4 examination chief. Whereas in the CrPC, affidavit is evidence normally not in all cases, but only in certain cases where public servant conduct is in a question, or evidence of formal witnesses is given under section 294 and 296. Dekho, no formal proof of the certain documents. Then under 296 ke andar evidence of formal character of affidavit, you don't need to examine the person directly, you can file affidavit. Whereas in the code of civil procedure, as a matter of right, you can file all affidavit. But cross-examination cannot be conducted by virtue of affidavit. Cross-examiner has to come in the court of law and give. Then when the documents are before the court of law, when the list of witnesses is there, then the learned judges pass order under 135 for admissibility and relevancy. So the document you produce, every document is not admitted as a matter of course. The court will see whether it is a primary evidence. It's a document, it's the original document under section 62 of the Evidence Act. Because section 64 mandates of the Evidence Act, the documents must be original, primary evidence must come on record at the first instant. It doesn't mean that the court will shut you from recording other evidence. If primary evidence is not available for reason, you have a right to lead secondary evidence under section 63 and 65. Even electronic evidence you are producing under section 65A and B, you must tell the court electronic evidence certificate is required. So those provisions are required to be. So the learned judges, the magistrate under the CrPC and civil judges will pass order under section 135 of the Evidence Act, read with order 13 CPC, that the document which is produced is original document taken on record, admitted, they give it a P1 document. Plaintiff का document देगा तो P1 देंगे, so defendant का document है D1 देंगे. But mere exhibition of a document, exhibition, contents are not proved. You will have to prove the contents. Suppose you are brought before the court of law the will of your grandfather for proof. There is a special rule under the Evidence Act for proving a will. Minimum one witness must be examined. Please see section 68 of the Evidence Act. Section 68 देखिए, 68 खोल लीजिए. Proof of execution of a document required by law to be attested. So attestation is necessary for a will by minimum 2 witnesses. See, if a document is required by law to be attested, it shall not be used as evidence unless and until one attesting witness or at least has been called for the purpose of proving its execution. If there be attesting witnesses alive and subject to the process of the court capable of giving evidence. So the condition precedent is that here section 68 says that if a document requires attestation, will, for example, will under the Succession Act requires attestation. So you need to examine one of the witnesses. Suppose one of them is dead or both of them are dead. फिर क्या करेंगे आप? Then देखिए proviso. Provided that it shall not be necessary to call an attesting witness in the proof of execution of a witness not being a will which has been registered in accordance with the provisions of Registration Act. So under the Registration Act, if the will is registered, you can make an application the witness be dispensed with. But the contents are required to be proved. Then see section 69. Proof where no attesting witnesses are found. Witness may be dead and gone or travel out of India. Address नहीं मिल रहा है आपको. In such an event क्या कहता है 69 check करो आप. If no such attesting witness can be found, or if a document purported to have been executed in the United Kingdom, it must be proved that the attestation of one attesting witness, at least in the handwriting and the signature of a person executing the document, is in the hand of that person. So, one of the person is not there, the testator is not there. In such an event here, when they are not found, one of the person, somebody who is familiar with the signature can be examined. The wife and the son can be examined. Then see admission 70 पे आ जाइए. Admission of execution by party to attesting document. The admission of a party to attesting document and its execution by itself shall be sufficient proof of execution. So if if the plaintiff say that my grandfather left a will, he died and the attesting witnesses are gone. If your brother defendant says that yes, the will is executed, but the will is my grandfather was not in a fit condition to execute it. Though the will is there, I am not disputing it. But at the time when he signed the document, he was not in a proper state of mind. That evidence is different. But there is admission under section 70. Under section 70, read with section 57, 58, admitted fact need not be proved. The will go in the box, can be admitted. Then the proof and attesting witnesses denied the execution. Let us see that here. If the attesting witness denies and does not recollect the execution document, its execution may be proved by other evidence. Suppose one of the witness or both the witness are not available. One of the witnesses say, I don't remember my signature. I become old. Then you can lead evidence of the person who typed the document. Yes, I typed it. I was the stenographer of the advocate. In my presence, the testator was there. My advocate told me to sign him. I have seen myself. So that's evidence is acceptable. Or the wife and son of one of the attesting witness or of the testator, any family member, servant. A servant can say that my boss, my employer had requested the advocate to come to his place owing to his old age and requested that I am going to make a will and that will be attested by two people, his friend, That is Mr. Neighbor, Mr. who is staying X, and another neighbor Y, and both are not there. I am a servant, I am looking after working with him for the last 50, 30 years, 40 years. So, when the attesting witness is not available, when he is denying it, the evidence of a servant, if the court finds that he is a trustworthy person, will be admitted. So, that is the way you prove the document here in the Evidence Act. So, the court will say that here the document is formally taken on record, but contents are not proved. The contents are required to be proved under 67, 68, 69, for example. Then handwriting expert के document का produce करने का है, वो section 45 से लेकर 50 तक है. The handwriting expert he sends a report, or your architect will give a report about the condition of a building or determines the mean profits. His report is not evidence. You have to call him as a witness. अगर मर गया तो then you have to examine his family members. Then only the evidence will come on record. If it's a copy which is in possession, a Xerox copy, then it will be a secondary evidence. The court will record it, the copy tendered is a secondary evidence. Secondary evidence. The plaintiff said that the original is lost. Then foundation should be laid down by the party proposing to lead evidence, secondary evidence. Namely, that he must satisfy the court, he has sent a notice under section 66 to the other side, or a person in whose custody the original document is there. Then produce the document, produce the letter before the court. This is what I have exercised my right. I called upon the defendant or his son or the registrar in whose possession the documents are there. They have not answered it. I have a Xerox copy. Then the court will accept the Xerox copy and record. If you take up the plea, the original has been lost and destroyed, then under the provisions of section 65, there are circumstances when you can lodge a police complaint. FIR was lodged. Despite my best diligent efforts, I could not trace it. In that event, section 66 notice is not necessary. Your evidence that you lost a document and you lodge a FIR, produce the FIR copy or a NC complaint, court will see whether the deposition is correct or not. Then you lead certain corroborative evidence under the provisions of section 156 of the Evidence Act. How do you corroborate? Mean other supporting witnesses must support your case. Question tending to corroborate, section 156 of the Evidence Act. Without corroboration, sometimes evidence may not be accepted. Sometimes a document may be very old, 30, 40 years old. So the court will say that court may presume that it's an old document. It may be correct, we'll take it on record. It's a original document, provided. That is admissibility will come. In the admissibility aspect, section 136 and order 13 ke andar in CPC, the court will give a finding, yes, the document is duly approved, taken on record, admissible. Before that, the court will ask you, you please give your say for denial and acceptance of document. That you have done also in the CrPC under the provisions of section 294 CrPC में किए हैं. So under the Code of Civil Procedure, order 13 के अंदर करेंगे आप, and Evidence Act के अंदर section 136 के अंदर करेंगे आप. Please remember the section very well. So denial, whether you are admitting the document, बाजू लिखेंगे इसके अंदर. Examination chief बाहर रहेगा, बाजू रहेगा, list of document. So you must be connecting all the document in an examination. I am producing the ration card. The ration card is standing in the name of my father. My name is also shown there. It has been issued by the public authorities. Then you may take up the court. This is coming from the corporation. The document come under 74 under the Evidence Act. May be taken the record, admitted. I have a passport. I have an election record to show and substantiate my possession after leaving that care. So passport is a public document. So the court will say that other side may take up the plea. The passport is a public document, I am admitting it. Or the document is forged, I am not accepting it. when accepting, when not disputed, then you summon the passport authorities for giving evidence in your favor, whether to produce the entire file relating to the issuance of the passport. If a letter is dispatched by registered AD by you to the defendant terminating his agency, terminating his tenancy, or calling upon him to produce document, calling upon him to give the document, वो बोलेगा letter मिला है नहीं मेरे को. The presumption will arise if registered AD से letter गया तो normally registered letter is reached. Plaintiff will produce the registered AD acknowledgement. It is signed also, the postal wrapper. So the court shall presume it is correct. But defendant will take up the plea. I was not in India when the letter was dispatched. Then the bonus will shift upon him. So you produce, where were you, in which country? I was in London, America, Dubai. देखिए ये मेरा passport है, this is my visa, this is my so and so. Then the plaintiff has colluded with the postman and taken the signature of a fictitious person. So, but the house is locked, and how can my signature be there? So that means you are discharging your burden. So the court will say that here the document which has been produced is not acceptable. Is rejected. The court will reject the document. If it is proved, duly proved, taken on record for admission, taken and take record and admission. So that provisions you should know very carefully. What is the court may presume, court shall presume, what is conclusive proof. So conclusive proof under the Evidence Act, only section 42, 112, 113. Decree passed by the family court. Decree and judgment, final decree passed by the High Court in insolvency matters or NCLC matter. Decree and final order passed by the district court or court in probate matters. So they are all conclusive unless fraud is played. So suppose a decree is passed by a family court or a civil judge, a dissolution of a marriage between A and B. Dissolve ho gaya marriage. A rich man, the husband dies, or a wife or the rich lady dies, and marriage is annulled. Marne ke baad, the husband, knowing fully well that despite the fact that the marriage is annulled, he will file a suit for declaration that I am the husband, I am entitled to decree, entitled to her properties. So her brother and sister will say that marriage between this plaintiff and my sister was dissolved by a family court decree, by a decree passed by a district court or a high court. I produce here with the certified copy. So that's a conclusive proof. That means this man, that despite having the decree having passed, he has made a false statement before the court. The marriage is surviving. The marriage was not dissolved, and he is still the heir and legal representative. So these are the evidence which you can lodge and dislodge here. That is in the case of conclusive. May presume, shall presume. 114 of the Evidence Act, remember kijiye. When the court, you are called upon the defendant to produce documents, income tax return, nahi kiya, the court can draw adverse inference. He is deliberately not producing the document because it will go against him. So the court may presume that here he is a culprit. And in the criminal prosecution, you are seeking to rely upon examining, you are examining the co-accused who has made a confession of guilt. Yes, I have committed the offense along with the accused number 2 who was a participant. He has the conspiracy and I executed it. समझे ना उसका that evidence 114B says that the evidence of this nature should be taken with a pinch of salt. Now, when you see the illustration to 114 of the Evidence Act, it tells you clearly, when you see that here, that the accomplice is unworthy of a credit unless corroborated in material particular. So the court will require the additional evidence. They will not convict B on the basis of the evidence of A. That evidence you will find under the Evidence Act that will be admissible under section 31 when a joint trial took place. Whereas in the Code of Civil Procedure, there is a question of joint trial doesn't arise because joint trial is in partition suits there will take place where all the parties are brought on record. When a mortgage suit for foreclosure, they take place here. So there are different nature of evidence which is led in CPC and CRPC, a slight different. Otherwise, the entire procedure is same. Okay. So may presume याद रखिए, shall presume के अंदर examples I gave you. A memorandum prepared by a magistrate or a civil judge with regard to the confession is admissible under 80. A civil judge has prepared a memorandum of inspection. The judge himself under Order 18 Rule 4, under Order 18 Rule 18 can inspect the suit property and prepares a memorandum that is admissible. It may not be technically strict evidence. It is admissible under the law. Under 80 can then the court can take into consideration, because under Section 4 of the Evidence Act, what the court says that the court will consider all matters before it, not evidence. Matters before it mean the evidence, documents, as well as suppose a bailiff report, a report of commissioner's report, which may not be technically evidence within the meaning of Section 3 and 4 of the Evidence Act, but they will be taken on record. So the findings are recorded here by the court, admissibility, relevancy under Section 136. Then after it is done, see, the examination chief ke andar, before the matter proceed for a cross examination, this admissibility done. But during cross examination, certain documents are produced by the other side. You have a right to object. This document which is producing is not admissible. So a separate list will be prepared by him. Again, the court will give a finding under 136. If the magistrate, if there is a commissioner recorded, commissioner will take question answer following judgment of the Supreme Court in Bipin Panchal's case, which I gave you last time. So finding must be, the commissioner cannot overrule anybody, cannot give a finding in that regard. So the role of entire Evidence Act come into play. Please note that here. And the provisions of Order 16, Order 18, provisions of Section 137, 138 and 118 of the Evidence Act should be ranked together. They must be given a harmonious interpretation in the matter. Then the trial court evidence closes. Then the matter traveling to the appellate court. The appellate court finding fault under Order 41, Rule 27. The appellate court has power to record evidence or remand the matter back under 41(23). Okay, this is the procedure. And witnesses examination, Order 16, remember very well. The court issuing summons, if summons are not respected, warrant can be issued by the civil court. Please note that here. Order 16 खोल लीजिए यहाँ पे. Order 16 के अंदर even a civil court can issue warrant. That I'll point out to some of the relevant provision. Then उसके बाद question answer ले लेता हूँ मैं आपके. More or less we have covered entire evidence here. Order 16 में दोबारा आ जाइए. Order 16, how the court can, when summons are not respected, warrant can be power to require person to give evidence and produce. See, Order 16 Rule 4 के अंदर court may give, tell the parties you come and give evidence and produce document. ये Order 16 Rule 7 के अंदर भी है. And under the Evidence Act के अंदर भी there is a provision where the court will such a provision 162 देखिए यहाँ पे, protection of documents. So during cross-examiner, some documents may come on record. The cross-examiner will tell you, you please produce the document which you are deposed. You say that, are you an income tax payee? Yes. Can you produce the income tax document for so-and-so year, assessment year? Are you a wealth tax payee? Yes, document. Oh, notice देंगे आपको. Under 162, you have to produce the document. Okay. This is a very important provision. Remember that here. So, Order 16 के अंदर Rules 7 में summons to the parties issue करेंगे when summons are not honored by the procedure. See, Order 16, Rule 10 provides here procedure when someone fails to comply. यहाँ के अंदर proclamation issue होएगा, warrant of arrest भी issue होएगा. Like under the CrPC scheme of CrPC, section 87, 89, 90 case, warrant is issued by the court of law. Magistrate is issuing, because 61 से लेकर, section 61 से लेकर section 81, how the court issues summons and warrant. CrPC के अंदर. Please remember the sections. 61 to 81 is a provision, and the CPC के अंदर order 16 is a comprehensive provision where entire summons and warrants are issued, and also attachment of the property can be done under the provisions of order 16, rule 10. Attachment will be withdrawn if the witness appears and pay the money. Under 11, then under order 16, rule 12, when he fails to appear, the court may impose cost upon him in the court and also issue warrant of arrest in the matter. Mode of attachment bhi karte hain. So don't take it that civil court will not arrest me or not attach the property is wrong. The civil court also has infinite powers. Again, under order 16 rule 18 के अंदर भी, when witnesses do not give evidence properly and do not produce document, the court will take strict action against them. Okay, no witness to be ordered to be attend witnesses so and so. Now, if it is found that here, if the witness has given false deposition, he is rendered for perjury, that evidence under the Evidence Act, I pointed out to you, witness cannot say that I will not answer this question. Isn't it? I pointed it to you while reading CrPC. That is relevant provision is a very important section that is, I'm pointing out, 132. Which witness not excused from answering on the ground answer will criminate. Now, under the Constitution of India, article, which article? Article, which is the relevant article in the Constitution of India giving you protection? We just mentioned, isn't it? Double jeopardy section, section 300 under the Constitution of India is article, anybody knows? 20, article 20, subclause 2 and subclause 3, to 1, 2, 3. Ex post facto law, incriminating and can refuse to answer question. Police officer asking incriminating question, like the case of Nandani Satpates versus state of Orissa ke andar. Isn't it? When the chief minister of Orissa was sought to be arrested and she was asked incriminating question, how much bribe did you take? How much bribe did you demand? I refuse to answer the question because it has a tendency to criminate me. When you open your article 20 subclause 3, that gives the protection to the accused person, that I will just refresh your memory. When you see article 20 subclause 3, check kar lo aap. 1920. See that? No person accused of any offense shall be compelled to be a witness against himself. That means incriminating evidence cannot be caused. Police officer cannot. But when a witness, when he is being questioned by the police officer, that's an investigation stage. When FIR is filed under 154, investigation begins under 156 onwards till 189 in the CrPC. So at this stage he can refuse. But under the Evidence Act, the evidence starts after framing of a charge in CrPC, and in the CPC after settlement of the issues. So the question 132 of the Evidence Act, he cannot refuse. If I will not answer this, if I answer this, I will go to jail. No, you have to answer. But the protection, you will not be arrested, but they can be perjury proceeding against you. The same court, a civil judge recording evidence can take criminal action against you. For that, please refer to section 340 CrPC. Please refer to section 340 CrPC. खोल लीजिए आप. This topic I will take it on Monday. I will just today point it out. Read and come. Chapter number 26 CrPC. Provisions as to offences affecting the administration of justice. So when the offence of perjury is committed by the witness under section 132 of the Evidence Act, read with section 192, 193, 194, 195 of the Indian Penal Code, can a civil judge who is recording evidence, can a revenue judge, can a municipal, can any other judge, or even a magistrate, can he take the accused in custody, or can he sanction his prosecution, is a chapter dealt under chapter 26 chapter 26 CRPC from section 340 से लेकर 340 से लेकर section 352, which I will deal with on Monday. Please note that here. So the witness cannot refuse to say that I have a protection under Article 20, subclause 2, I will not answer. No, that protection is only at the investigation stage against the police officer. But when you are before a learned judge, before a judicial magistrate first class, second class, civil judge, senior division, junior division, city civil court, small causes court, cooperative court, or a revenue court, or before the high court, original site, recording evidence, you must answer this question. Please read section 132 and come. Read the provisions of order section chapter number 26 CRPC dealing from section 340 से लेकर the provisions ending with 340 से लेकर I'm just giving you the last section 352. Please read and come Monday. This is the chapter which I am going to take. The effect of perjury and section 193, 194, 196 IPC भी पढ़ लीजिए आप. This is very important. What action can be taken by the civil judge, criminal judge against the accused person when he deposes wrongly? That is called perjury proceeding. पढ़ के आइए आप. This I will discuss. Now, anybody has any question, we can wind up today. What is the time now?
It is 9 o'clock, sir.
अभी बंद कर देंगे. Stop करो. Question answer. You want further? IPC के अंदर पढ़िए आप सेक्शन फैब्रिकेटिंग फॉल्स एविडेंस स्टार्टिंग फ्रॉम सेक्शन 191 चैप्टर 11 IPC के अंदर गिविंग फॉल्स एविडेंस, 192 फैब्रिकेटिंग फॉल्स एविडेंस एंड 193 punishment for false evidence, 194 giving fabricating evidence for capital punishment. ये पढ़ लीजिए आप. This chapter is starting from section 191 191 से लेकर 191 से लेकर till what section it is?
191 से लेकर
190 से it is a yeah 212 तक है, sorry 211 तक है. False charges offense made with intent to injure. 211 तक पढ़ के आइए आप.
Okay, sir.
Okay, that is IPC का.
Yes, sir.
Okay, today we'll wind up. Today we stop because I did not want to bore you all. 2 lecture हो गए अभी. Anybody now? I will take up questions. Any question, maybe 10 question, 15 question, 20 question. Ask me how far you understood now in CPC, CRPC and Evidence Act. This is very relevant. पूछ लीजिए क्वेश्चन मेरे को अभी. Nobody has any question today?
No, sir, I don't think anyone has question.
Why? We dealt with so many chapters and so many sections, CPC, CRPC, Evidence Act, सब याद हो गया आपको? सब याद हो गया? I think you will go and revise the lecture, this video and tell me tomorrow, day after tomorrow.
Okay, sir.
Monday का दिन question पूछिए इसके अंदर. Then I will tell you the effect of after having given evidence in CPC and CRPC Evidence Act, when your evidence is false, can you be prosecuted? What is the punishment? Can the civil judge recommend a prosecution? Yes. City civil court, high court judges can launch prosecution. So उसके भी provision check करेंगे. Section 190 से 195 से check करेंगे. वो पे पढ़ो आप CRPC के अंदर. Please, that procedure, that complaint, who can file it? You cannot file directly. A plaintiff and defendant cannot file it. Please note that complainant should be the court where the false evidence was given. उसका provision में बता देता हूँ आपको मैं. वो पढ़ लीजिए एविडेंस एक्ट CRPC के अंदर सेक्शन 195 prosecution for contempt of lawful authority, public servant, for offences affecting public justice. please read section 195 and come.
Yes, sir.
Okay? The complaints which a civil judge can file. As a plaintiff in your suit, I have given as a defendant wrong evidence. You cannot file a suit, criminal case against me. It is the civil court in the High Court, Bombay. While giving evidence in a probate proceeding, I made false statement. I produced bogus letters. The judge, while recording evidence, if he finds that I committed perjury, I am giving forged evidence, he will tell the Prothenotis Senior Master High Court, Bombay, issue notice to him and send the matter for a criminal prosecution to the Chief Judicial Magistrate in Bombay. Other places, Metropolitan Magistrate in Bombay, Killa Court, and other places, Chief Judicial Magistrate. वो action लेंगे. The courts, High Court itself, they become the complainant, and the trial will take place in a criminal court following the provisions of section 25, 26, 27, and we laid it in the CrPC. Huh? Who can try which trial, isn't it? That I will discuss with you once again. I will recapitulate your memory. So read and come these provisions. Okay, if anybody has any basic question, please ask me before we wind up. Almost 1 hour is over, isn't it?
Yes, sir.
Okay. Okay, all the best to all of you, and I wish you happy festival tomorrow, which is the Ganesh Chaturthi, isn't it?
Yes, sir.
Yeah, all of you enjoy, and best wishes to all of you for the festival. And we'll meet up directly on Monday, isn't it? Monday.
Okay, sir.
Monday we'll have one lecture only, and 7 to 8 o'clock.
Okay.
That, because I do not want to bore you every time. एक lecture लेंगे, time है हमारे पास. I will take 340, 341. उसके बाद, what does the judges, criminal judges do? Evidence खत्म हो गया, they pass judgment, वो सब लेंगे मैं, वो भी लेता हूँ मैं. Judgment होएगा, conviction होएगा, conviction sentence होएगा, how much to be award sentence, उसके बाद appeal होएगी, revision होएगा, what are the provision, वो भी ले लेंगे. I think though I covered initial stages में, and I will again go more deeply in the matter. Okay then, all the best everybody, then see you.
Yes, sir.
Okay.
Good night, sir.